So, good morning. You are listening to us on The Good Fight with Steve and Josh, attorneys at law. We're driving actually to an ex-party in downtown Los Angeles, Stanley Moss Courthouse, on a divorce matter that we have going to trial in a few weeks. Actually, there's a trial setting conference this Friday. The case was originally set for trial in Pomona, but once the judge realized it was going to be more than a 2-hour trial, it got kicked to downtown LA. So there's been a sort of recent development in the case, and we're going to go over it in a second. I'm actually going to read you the introduction, or the sort of procedural history and the facts that lead to our necessity to go in ex parte. Ex parte is just a fancy Latin term for an emergency hearing, or there's an exigent circumstance which necessitates the need for immediate court intervention. And so this is on a divorce case that we have. And so Josh actually wrote this motion, and we're going to go in this morning and file it and have it heard. And obviously the idea is that it's granted and that the judge grants the relief that we seek. Let me read you the title of the moving papers of the ex parte application. It's a notice of ex parte application and application for an order granting respondent, which is us, leave of court to depose a certain individual and or any witness petitioner intends to call regarding his ability to refinance the community residence. And that's one of the issues in the case, is that our client, who's the wife, lives in the property and has been doing so since the parties purchased the property. The soon-to-be ex-husband moved out about 10 years ago. Is that right? And so she's lived there ever since, and she's got a really strong emotional connection to the property. She wants to keep it. He wants it too, and that's the fight at the heart of the trial coming up in a few weeks. And so let me just read you the introduction. I'm going to ask Josh some questions about it, get into his brain a little bit. So again, we're a respondent, and who's the wife? Respondent seeks to depose a certain individual who happens to be in the mortgage lending industry, and or any other person that petitioner intends to put forth to testify about his ability to refinance the community residence. Petitioner has put forth a pre-qualification letter, attached as Exhibit B, allegedly authored by, let's call him Joe Schmo. Respondent has good reason to believe that Joe Schmo did not author this pre-qualification letter. 2, that petitioner fabricated said letter. And 3, petitioner has not been qualified by any lender to refinance the community residence. It is paramount that respondent be given the opportunity to depose Joe Schmo and or anyone else that petitioner purports qualified him for a refinance of the community residence. Deposing said person will help determine 1, whether petitioner is in fact qualified to refinance the community residence, 2, the credibility of petitioner and his willingness to mislead the court and fabricate documents, and 3, the merits of Family Code Section 271 sanctions. For these reasons and the reasons set forth below, respondent respectfully asks the court to grant her ex parte application. So it's a kind of a unique situation where we have reason to believe that I'm going to have Josh get into the facts of that, but reason to believe that petitioner, in this case soon-to-be ex-husband, has literally fabricated documents in an effort to mislead the court into the allegation that he has been pre-qualified for a refinance, which is one of the issues in the case. So Josh, I've read your motion. It's very persuasive. I'm hoping that it's going to get granted. I'm very confident in that. Okay, so Josh, what I'm interested in knowing is what legal, we talked a little bit about the factual basis necessitating the need for this ex parte, but what legal basis is there for this ex parte application?
So CCP 2024.050 allows the court to hear discovery motions, to reopen discovery after this discovery cutoff has already occurred, right? So 30 days prior to the trial date for regular discovery, 15 days for irregular discovery motions, 10 days for experts, 5 days for expert motions. So this allows the court the discretion and the power to hear or reopen discovery issues after those cutoff dates have occurred. And so there's some factors that go into it. I think there's 4 factors. The first being the need for the discovery. The second being that there was diligence or lack thereof. The third being that nobody will be prejudiced and the trial date will not be affected, or if so, to what extent, by allowing discovery to be reopened or allowing the motions to be heard. And for the amount of time that has lapsed, if you're trying to to reopen discovery after a trial date has passed, the time that has passed between the previously said trial date and the future trial date.
Okay, so what I think you're saying is that if this was a brand new case that was filed and trial was a year out, would we need to bring this ex parte application right now?
No, I don't think there would be an issue. It's pretty obvious the relevance of the depositions that we're attempting to take, and that I feel that we're entitled to by law. The issue here is that they think that they can preclude us from taking these depositions based solely on the fact that it comes after the discovery cutoff. And that's just it's not kosher with public policy. Public policy has always been and will always be in favor of disclosure for purposes of understanding what your position is prior to trial and the merits of your claims and defenses. Along with, with trying the case on the merits here, it's a dispositive issue. Whether or not this person is qualified to refinance the property is a dispositive issue. It determines whether the court can award the property to a party or whether it needs to force the sale of the house. And so not being able to have that information prior to going to trial and putting somebody that could potentially be a loose cannon on the stand would cause irreparable harm to the party if that were the standard.
And so if I'm the judge on this case, and let me play devil's advocate here, if I'm the judge on this case hearing this ex parte, one of my first questions would be, Mr. Genzik, why didn't you simply depose this individual, Joe Schmo, 6 months ago?
And that requires a factual analysis. The facts in this case are that the need for the deposition didn't arise 6 months ago. 6 months ago, there was no question that either party could obtain financing. They both make decent livings, and in fact, our client got approved for a significant amount of financing to refinance the property. But since then, the mortgage has gone 60 days past due, and we have reason to believe, and good reason to believe in that, after talking to our client's potential lender, that nobody associated with this property is financeable with the 60-day late mortgage, at least from a conventional perspective. And even from a non-conventional loan perspective or an unconventional loan perspective, it's highly unlikely. And so there was no need to conduct this deposition 6 months ago. It wasn't until we got that information from the lender that it became even an issue a little bit. And then after discussing it with opposing counsel and making them aware of what was going on, they delayed and postponed getting us the information, getting us any sort of evidence of a pre-qualification on their part. And then on the eve of trial, they produce a letter from somebody saying that he's pre-qualified for what happens to be the exact amount that he needs to be pre-qualified for. So it just doesn't pass the smell test.
Right, well, let's talk about that smell test, because what specifically smells funny as it relates to Joe Schmo? So have you spoken to Joe Schmo? What does he have to say or not say?
Well, after our last trial day got continued, we got kicked downtown, long cause. I informed opposing counsel that I intended to take this person's deposition. Okay. And there was no objection to it. She had no issue with it. And we, in fact, noticed the deposition. We subpoenaed him for deposition.
Subpoenaed Joe Schmo.
And we subpoenaed Joe Schmo, and he didn't show up for his deposition. It was scheduled a couple weeks ago. He didn't show up. And then just about 2 days ago, he called the office and wanted to know what everything was about, and he informed us at that point that the letter that we had in our hands he knew nothing about. He wasn't associated with the company on the letterhead. He wasn't aware of its contents or its creation, and he agreed to come in and testify to that.
And independent of this revelation or new fact, is there a reason to believe that petitioner is capable of forgery or fabrication of documents, anything like that?
Yeah. Granted, they're unsubstantiated, but we have also good reason to believe, just by using our eyes, that the petitioner has forged loan documents in the past with our client's signature.
And specifically, loan documents related to real property.
Correct.
And I think that one of the pieces to the puzzle that fit into this theme of, kind of like if that person can have it, no one can. And here, petitioner, I think, establishing and pretty sloppily, if that's a word, in a sloppy fashion, demonstrating that he's willing to do whatever it takes to obtain this property. Lie, deceit, fabrication, whatever. And so that's the main driving factor in our need to depose Joe Schmo, because the fact is that this letter that we got very recently, which came from opposing counsel, which obviously then came from the petitioner himself, we have good reason to believe was fabricated, was made up. And so necessarily it means that petitioner obtained this through deceit, through false pretenses, whatever you want to call it. In other words, it's not like he opened the mail one day and found this pre-qualification letter. No, the idea is that if you want to get financing, or in this case refinancing for a house, you go and you talk to individuals, and you go and you submit an application, you go and you have your credit report run, and you take affirmative steps to get to a point where you receive this letter, right?
Yeah.
And so
look, there's a couple things here, right? The first and foremost is that, look, if the opposing party didn't do anything wrong and there's no fabrication here, then why are they fighting? Why
Exactly.
are they fighting this deposition
Good point.
so much?
Good point.
Right. If there's no smoking gun here, then what's the issue? Right? This guy's just going to tell us that he's pre-qualified, and then we eat our words. That's what it would come down to, right? But there's a reason that at 8 o'clock on a Wednesday morning we're driving downtown LA for next party.
Yeah, and there's something you just mentioned that reminded me of another fact in this case. What is it? It is that. I remember. So, tell me, Josh, a little bit about hearsay, and specifically, wasn't there a motion in limine that we prepared prior to the original trial? Was supposed to be in Pomona, right? And we were ready for trial. We called ready that day, but prior to that, we had filed the motion in limine. Talk to us a little bit about the subject of that motion in limine, why it relates to this issue.
So that motion in limine dealt with this pre-qualification letter that we've been talking about, and there was nobody on the petitioner's witness list that was going to be able to lay the foundation to get that pre-qualification letter in. Now, the petitioner himself could have talked about that he was pre-qualified and what he was pre-qualified for, but any evidence of that itself, other than his testimony.
You mean the amount?
The amount. He could have testified as to the amount, right? Because if he read the letter or had a conversation with somebody, he would have personal knowledge of that. At least in my interpretation of it, I think that he could have testified as to the amount. Mm-hmm. Now, I don't think that he obviously could not lay the business records foundation to get this actual document in.
Right.
And so at that point, the trier of fact would have only his testimony to base their reliance on, in that he was actually pre-qualified here.
And here the trier of fact is the judge, right? Because there's no jury.
The judge, exactly. And so without that document, I'm just it's my interpretation that it's not very credible. Mm-hmm. And I think that this makes it even less credible, right? The fact that he may have fabricated that document to begin with.
Right.
So
exactly.
I think that, we've been getting pushback from opposing counsel, but I think it's, credibility is always at issue, is really what it comes down to. But, everybody has to advocate for their clients, I guess.
Yeah. No, but it's interesting that opposing counsel is fighting this ex parte so vehemently, because I personally think that it says a lot about the genuineness of this letter and the credibility and veracity of their client. Yeah. And they're covering up for him, if I'm being honest.
Yeah, and I want to give them the benefit of the doubt. I want to give opposing counsels, both of them, the benefit of the doubt in that they didn't know that this had occurred, right? But I
think the writing's on the wall. I think we've established that to opposing counsel very clearly, and not just as it relates to this document, because we have shown them a document in the form of it was a loan modification document, and a loan modification agreement. It was a contract that our client's signature looks very, very different than another signature that we know was in fact hers. So, and then of course there's the original issue that got us to this place and got us into this case in the first place, which was that petitioner, we believe strongly, obtained a default judgment through deceit. I forget. I think the issue was that he had a process server allegedly served. Our client maintains that she never was served with the summons and petition, and I believe her when she says that. And we were successful in setting aside the default judgment, in large part on the lack of credibility, at least that's how we alleged it, of petitioner. And this was Judge Christian in Pomona who agreed with us on that issue. And again, I think we used at that point in time the loan modification document to sort of put his credibility at issue. And so here we are again, really full circle in a way. Anyway, so that's our case. It's getting close to when we need to be filing this, so we're going to sign off. But thanks for watching, and hope to see you next time. Thanks for watching The Good Fight. Goodbye.